Car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis Wright and host David Lamb.
Hello and welcome into the attorneys. Thank you so much for joining us on this Sunday evening. We have a panel of experts assembled ready to deal with a subject matter that we think is of interest and pertinent to you. So we look forward to the next half hour. A couple of ground rules. First of all, if you'd like to join the conversation, you'll see ways you can do so at the bottom of the screen all throughout the program tonight. And attorneys from Hollis Wright are standing by live right now to speak with you. So if you think of, in the midst of the program tonight, think of a question you'd love to get some legal advice on, you can pick up the phone, dial that number, and have an off-air confidential conversation with an actual attorney from Hollis Wright. So a pretty neat deal. Leading our conversation from the firm of Hollis Wright, Carter Clay. Good to see you, sir.
Good to see you, David. I hope you're doing well.
Doing well, thank you.
Great. Yeah, tonight we're going to be talking about family law and in particular divorces, child custody, child support, alimony type issues, all of those things that kind of arise out and through divorce proceedings.
Right.
And unfortunately, we still live in a society where about 40 to 50% of marriages throughout the country wind up ending in divorce. And of course, the majority of those divorces that don't involve children are fairly routine and are categorized sort of as an uncontested divorce. But obviously, as we all know, when people have children, that really complicates matters a lot and makes the divorce proceedings very challenging and difficult, especially if the children are minors and as they get older through high school and college and those types of things. And so that's what we're going to be talking about here this evening. And we're very fortunate to have Carthenia Jefferson here with us. She's a practicing attorney here in town. Welcome to the show, and I'm really looking forward to the information you have to share with us.
Well, thank you all for inviting me, and I appreciate being here. And I hope to be able to enlighten our audience and provide some information that will be helpful to the citizens of Alabama.
Well, great. Well, tell us a little bit about your background and your legal practice and how you got involved in this area of the law.
Well, my background is I started off as a nurse, and I still am a nurse. I have over 30 plus years of nursing experience, and I've been doing legal practice for over 12 years. And I have a practice downtown Birmingham. I'm a solo practitioner, and I do a lot of family law. I love serving families, and I try to provide help wherever I can. My motto is, if I can help somebody as I travel along the way, and that is providing services to the families of Alabama and throughout this nation, wherever I can.
Right. Now, with respect to divorces, there are essentially two different routes, I guess, that a divorce can take. It can take a contested route where there is a dispute over various aspects and issues of property between the husband and the wife, and maybe other matters as well. And then you've got the uncontested route. Talk a little bit about the uncontested versus the contested route, and I guess express to the viewers that kind of the differences in the cost of going through an uncontested divorce versus a contested divorce.
Uncontested route of divorce is that usually persons, the family, the male and female, usually they have an agreement, and it is less costly. Usually they have assets where they have already decided they're going to split those assets or divide those assets up. A lot of times they don't have any children in that the marriage, and the cost, like I said, is very little. So in that route, they usually have an attorney. Sometimes they have one attorney, and that attorney drafts that agreement up, and they go to the court, and they get their marriage dissolved that way. Versus a contested divorce, where that is a costly matter. Usually they have assets, child custody involved, and sometimes it gets to be a long, drawn-out process. I usually try to tell the parties to try to go through counseling. Sometimes they take counseling, sometimes they do mediation, but it is up to the parties. Sometimes the judge also orders mediations for the parties, but like I said, it is a drawn-out process for the parties.
And one of the important aspects that you just touched upon that really can kind of influence the cost of a divorce is that in the uncontested route, the husband and wife can get together and really hire one attorney to handle the proceedings, whereas if it's contested, obviously they both have to get their own individual attorneys to go through the contested proceedings, and that can add a lot of cost to it.
Yes, it is. Yes, it can add a lot of cost, and it can be drawn out. And a lot of times the parties, because of disagreements, over the assets or just disagreements because of just petty stuff, they draw out the process a long time.
What are sort of, in your judgment, I would say maybe the top 3 kind of sticking points that a husband and wife have as part of a contested divorce? I mean, is it a matter of with children and the support of the children and the custody of the children? Would that be in the top 3 or even number 1? What are sort of the top 3 areas there?
The top 3 areas usually are custody of the children, child support, and then the assets, dividing the assets. Those are the top 3 areas that I see.
All right, we got some questions here. I'm going to just toss them to you since you're the expert here. This has to do with a business. So the question here: my father started a business that I now own since my father's retirement. If I file for divorce, will I have to split my business with my wife, who has worked there for years?
That usually depends on the whether the property was received prior to the divorce, and also whether it's considered common property. If it was received during the divorce and it was considered as common benefit property used for the common benefits of both parties, then they may have to split the property. But it really depends.
And of course, maybe one of the more important terms in that question is the word split. Are we talking about splitting up the profits associated with the business, or are we talking about breaking up the business and in divisions between the husband and wife? And that's a critical issue, because obviously a court is going to look at a business, and if it's a profitable business that has several employees, the last thing the court wants to do is to break up the actual business, to shut down a business over a divorce. And also, if you've got children involved, it would be foolish to break up the business, because that's the income that the parents are using to provide for the children. So they're going to look at ways around that to equitably maybe divide up the profits flowing from the business. But that is a very complicating issue that the courts have to address in dealing with a divorce proceeding.
And as Clay said, that is a very complicated matter, and that's why I just tell persons it's not as easy as it seems, like a yes or no answer.
Right.
That's why I tell persons to seek a competent lawyer to answer that question, and just not rely on the information that we give you today.
That sounds good. All right, time for us to step aside our first break of the evening. As we do so, a couple of reminders. Would love to have you check out the firm of Hollis Wright on social media, Facebook as well as Twitter. A great educational resource for you, so follow us and we'll provide some pretty interesting stuff, if I do say so myself. Stay tuned. We got more of the attorneys coming your way next.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm. Thank you for watching The Attorneys. Now, we hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to the show or related to other accident or injury-related topics, you can call, email, or text us. Or you can also follow us on Facebook or Twitter, or simply contact us by going to hollis-wright.com and click on the Contact Us link. We know your time is valuable, so thank you for spending it with us watching The Attorneys.
All about family law and divorce tonight on The Attorneys. We appreciate you being with us. A reminder, attorneys from Hollis Wright standing by live right now to speak with you. All you have to do is pick up the phone and give them a call. Carter?
Yeah, Carthenia, let's talk a minute about child custody and child support issues. In terms of child support, can the parents agree in the course of the divorce about what the amount of the child support is going to be, or is the judge going to insist upon having influence over that?
Alabama has a child support guidelines, and usually it is established by the guidelines for the state. And usually those child support guidelines are determined by income of both parents. So based on the income of both parents, and that income guidelines can go up to $240,000, and it's based on, like I say, the income of both parents. It's based on insurance, and it's based on also the health costs of the medical costs. So based on those three factors, there's a calculation factor, and based on that calculation factor, the child support is determined by that factor.
So there's really a formula that the court is going to look to in order to establish the child support payment. So it's really not something that the parents can just arbitrarily agree to. And I would imagine that the court, while they may consider the wishes of the parents in that regard, they're going to look to the formula, because the formula probably has underpinnings to it that provide for the best interest of the children.
And that's correct.
Okay. Now, one of the questions that I have, because we don't handle these types of cases, but we do get calls all the time about divorces and child custody type issues, and that is that if after the divorce proceeding takes place and the parents are divorced from one another, if at some point in the future one spouse loses their job or they sustain a blow or reduction in their income, do they just get to arbitrarily reduce their child support payments, or do they have to go back to court and petition the court for some type of modification?
They can file a petition for a modification, but the judge has a hearing on that, and then the judge gets to decide, based on that material change in circumstances, if they would modify the child support.
Let me ask you one other question too. I'm going to deviate for just a second, because I have seen this come up and been asked this question before, and that is, what if one spouse wants to get a divorce, but the other spouse does not want a divorce, and the spouse that does not want the divorce just refuses to sign any documents, refuses to participate in the legal process? Can the person that wants a divorce go it alone and go through the process and ultimately get a divorce? How do those situations work? Because I've seen that from time to time happen.
The person who wants a divorce can file for a divorce, and then the person who does not want the divorce can answer or not answer. If the person does not answer, then a default judgment can be granted, and the person who wants the divorce can get the divorce. But if the person who does not want the divorce does answer, then they will have a hearing on the matter and maybe a trial, and the divorce still can be granted.
Yeah.
And it just depends on the grounds for the divorce.
So if you don't answer or don't respond, it's not as if you can prevent your other spouse who wants a divorce from getting a divorce. Basically what you're doing, though, is you're foregoing your right to have your case heard or your voice heard relative to your wishes and desires about the divorce proceeding, and the spouse that wants the divorce can just essentially go in, tell the court X, Y, and Z, and then the judge is going to make a ruling.
Yes, that is correct, because they're going to give their testimony whether you answer or don't answer. And if you don't answer, as I stated, a default judgment will be granted, and the person who wants a divorce would receive it anyway.
All right, question we've got here. Can a court order that my husband keep medical insurance coverage on our children until they reach 18 years of age?
A court can order that the spouse or the husband or another person, if even if they're not married, be ordered to pay for medical costs up until the child reaches the age of 19.
Now, how about education, college education? Because I know that that's kind of been a hot topic over the last few years about whether or not a divorced person or parent is required to pay for the college education of their children. What are the rules on that right now?
Well, ex parte Bailey's did establish that a parent did have to pay for a college education. That was a 1989 case. But ex parte Christopher, back in November 2013, the Alabama Supreme Court stated that a parent no longer had to pay for education, college education, after the age of 19 for a child. So that is a long, it put a lot of implications for a lot of parents who were depending on that college education to be paid by that the parent. So I tell parents now, do not, unless that you have a prior judgment already, that parent still does not have to pay for college education after the age of 19 because of ex parte Christopher, which was established by the Alabama Supreme Court November of 2013.
Yeah. Now, how about property in general? How are the assets or property in general divided up in a divorce, and what is the court looking at?
It's equitable division, but equitable does not mean equal, and I just tell people it means fair. So you're supposed to list, the attorney's supposed to ask for discovery, which you list your assets. If you don't list your assets, they still can get discovery through subpoena, because sometimes persons will try to hide their assets. And like I said, it's equitable division, but it does not mean equal division, it just means fair division.
And I've often heard of times where they're like parents of children that are married and perhaps they're not very fond of the person that they married. Maybe they try and set up trust and things like that to prevent their inheritance or property from actually being a property or asset of the marriage, to try and preclude the other person from getting to the assets. Does that happen from time to time?
That does happen from time to time, but that's why I say the attorney's supposed to do their due diligence and seek discovery, and that is ask for the information. And if they feel like they are not getting the proper information and that the spouse has told them, or their client has told them, yes, there is other assets that the other party has not given, then they seek that information through the subpoena.
All right, a question we have here. What can I do if my ex-spouse is not providing court-ordered child support or alimony?
Then you file what we call a Rule Nisi, which is a contempt order, a contempt petition through the court.
Right.
And the court, hopefully, you will have a hearing, and the judge will, you will go before the judge, both parties will go before the judge, and if the other party is found in contempt, then that party, the judge can rule that party to either reduce the, if it's child support, reduce the child support arrearage, or if the person is found in true contempt, can also incarcerate that person, can send a person to jail. And I tell persons that all the time. Right. You can go to jail. I don't know if you know that or not, right, but you can be ordered to go to jail. Whether you're a doctor or lawyer, the judge will send you to jail.
Right. Right.
Yeah, and that's the point that I was trying to make earlier. If you lose your job or lose income, don't just arbitrarily stop payment. You're going to have to get the court involved and explain to them that you no longer have the ability or the income to make those payments.
Right. All right, time for us to step aside for our final break of the evening. As we do so, I want to remind you of how you can get in touch with the firm. You can see right there ways to call, text, email as well, and a great website. Check them out online, hollis-wright.com. Stay tuned. More of The Attorneys coming right up.
I'm Drew McNutt with the law firm of Hollis Wright. We often get asked what happens if someone is injured by a motorist who doesn't have any insurance coverage. In tonight's Legal 411, we will address uninsured motorist coverage. Under Alabama law, all automobile policies issued must provide uninsured motorist coverage unless the name insured rejects the coverage in writing. If you purchase this coverage and you are injured by an uninsured driver, you can make a claim against your own insurance company to compensate you for the injuries caused by an uninsured or underinsured driver. While liability insurance is required by state law, it is estimated that over 20% of the motorists in Alabama do not have any coverage at all. Uninsured motorist coverage provides you with the ability to protect yourself and your family in the event you are injured or killed by one of these uninsured drivers. If you are concerned about whether you're covered, I recommend that you check your declarations page or contact your insurance agent to discuss your coverage options. If you do not have uninsured motorist coverage, consider adding it. And if you do have it, discuss increasing your limits. Oftentimes, you can purchase hundreds of thousands in coverage for less than $100 a year. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on the real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks for watching The Attorneys on WVTM 13.
Welcome back into The Attorneys. About 7 minutes or so remaining in the show. So if you want to take advantage of that opportunity to speak with an actual attorney from Hollis Wright standing by live right now, you got a few minutes remaining. So pick up the phone and give them a call.
Carthenia, let's talk a minute about alimony. How does alimony generally work in the state of Alabama, and what is it and how is it structured?
Alimony is considered spousal support, spousal maintenance. The purpose of alimony is to preserve for the status quo of one of the spouse. What it is, the alimony, there's various factors as far as alimony is to determine, like I said, to preserve the status quo. The factors that's considered is the standard of living, the age of the other party, the health of the other party, the conduct of the parties as far as what's causing the split of the marriage. And the alimony is also as far as the property, the common property of the parties. So those are some of the factors that determine the alimony.
Do you have to be married for a certain number of years in order to trigger an obligation to pay alimony at all?
It has to be, as far as the alimony is concerned, you really don't have to be married a certain number of years. Sometimes I think people look at alimony and retirement. In the retirement, you have to be married a certain number of years to trigger the retirement, and that's 10 years.
Okay.
But as far as the alimony itself, no.
Okay, and is a husband who stays at home and the wife works outside the home and she's the breadwinner for the family, is the husband eligible for what I think they refer to as palimony? Is that right?
Yes.
And does it work the same way?
It does.
Okay, and so in terms of the alimony, they're going to look at a lot of various factors, or the court will, in order to determine the amount of alimony, correct?
That is correct.
And again, if the spouse that is ordered to pay alimony just all of a sudden stops paying, what should the other one do? Is it another petition to enforce payment?
Yeah, the court has ordered alimony to be paid, and one spouse just stops paying alimony. You file that same petition for rule nisi, and that's a contempt order, and you go to the court usually orders a hearing because you just cannot stop paying because you have, whether you lost your job or not, the court needs to know, and the court has a hearing, and you have to explain to the court why you stopped paying, and the court makes a determination whether that payment should be reduced or whether if you just stopped paying because you wanted to, whether the court will send you to jail or what the judge would do in that situation.
Now, I've often heard if the person receiving alimony gets remarried at a later point in time, it automatically terminates their receipt of alimony. Is that true?
That is true.
Okay.
Question we've got here. My ex-wife wants to relocate with our child who we share custody of. Can I stop her?
Because of the Relocation Act that usually puts in divorces automatically, you have to give usually a 30-day notice. And if that 30-day notice is not given, say if you have a job and you have to change jobs and you have less than a 30-day notice, you have to give notice as soon as possible. But usually the Relocation Act requires that you give at least a 30-day notice.
And I think, isn't there a presumption that it is not in the best interest of the child for the parent that has custody to be allowed to relocate? So you've got kind of a higher burden to overcome if you're trying to take the children out of state?
Yes, because of the couch standard, and the couch standard is the best interest of the child. It's always, the court looks at that. And so that is why the Relocation Act requires the 30-day notice. And with the 30-day notice, you used to send a certified letter. I tell my clients, send a certified letter, because sometimes they'll say they didn't get the notice, but with that certified letter, you have that notice that you did send it in a timely manner.
Yeah. Just a couple minutes remaining, and we're just about out of time. I want to give both of you thoughts, time for some final thoughts. Ms. Carthenia, if you would go first, please.
My final thoughts is that with divorce, I always tell people, try the uncontested first if it works. If not, if you cannot come to agreement as far as working with a mediator, that's always the cheapest route. But if you cannot do that, try to come to an agreement. If you cannot do that, try some counseling. If you cannot do that, then seek competent legal assistance. As far as child support, child custody, try to work toward that in the best way possible. But as far as college, parents remember that you cannot get college assistance past the age of 19 anymore.
19 is it. 19 is it. Carter, real quick.
Yeah, I was just going to say this is an area where emotions are running high.
Yeah.
Try and narrow the issues as much as possible. Reach agreements before you have to get to a lawyer and before you have to go to court. That will cut down on costs dramatically and really do yourself a favor in that regard.
Good advice. Appreciate both of you being with us tonight. Thanks so much for the time, and thank you as well. We appreciate it always. We'll look for you next time right here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.